Okay, good morning. Welcome to another construction question time with Brandon Silver. Welcome, Brandon.
Good morning, Julie. How are you?
I'm good, thank you. I understand that today's burning question that you're going to be answering is, what is a quantum meruit, and when can you make a claim for payment under the principle of quantum meruit? Explain, please.
Yeah. So firstly, today I'm talking about quantum merit. So firstly, I'm going to explain what it is. So quantum merit, it means the amount he deserves. And in most cases, it denotes a claim for a reasonable sum in respect of services or goods supplied to another party. So it's basically a claim for a reasonable sum. Now, this claim for a reasonable sum can only arise in certain circumstances. Now, the one circumstance where it definitely cannot arise is where the parties have entered into a contract, and one of the terms of the contract is to pay an agreed specified sum. If that's the case, then of course it's not a claim for a reasonable sum, but it's the claim for the sum as per the contract, and therefore the quantum merit principle wouldn't apply here. So I'm now going to go over 5 different circumstances where the quantum merit principle would apply and a party can claim a reasonable sum. So, number 1, when there is no contract between the parties. If there's no contract between the parties, then a party could claim payment under the quantum merit rule. So, question that follows, well, when is there and when is there not a contract? There would not be a contract if any one of the 4 following elements would not be present. This is because these are 4 elements that are key to the formation of a contract. And they are, number 1, offer. Number 2, acceptance of that offer. Number 3, consideration. And finally, number 4, intention to create legal relations. Now, just briefly, consideration is where there's the promise to pay a certain price in exchange for services or goods supplied. So that would be what you need to satisfy for the consideration part. So that's number 1, where quantum merit would apply and you could claim a reasonable sum. Number 2 would be where terms have been agreed between the parties, but only some terms, and other terms remain unagreed, such as, for example, price. In this case, again, quantum merit would apply. The third of number 5 circumstances would be where the parties have entered into a contract, but the contract simply states that the party will pay a reasonable sum and is no more specific than this. Then, of course, again, quantum merit would apply and could claim a reasonable sum pursuant to this doctrine. Number 4 would be when the parties have entered into a contract, but unfortunately, for some reason, it is later found that the contract is either unenforceable or void. The final circumstance is where there is works that have been taken place which fall outside of the original scope of the works and do not fall to be valued under the contract's variation mechanism. So in this example, specifically the works that fall outside of the contracted scope of works and do not fall to be valued within the variation mechanism, they would be claimed pursuant to a reasonable sum for those works. So those are the 5 examples. The question that follows from this is, well, what is a reasonable sum? We know what quantum merit means. We now know when it doesn't apply, but how do we know what a reasonable sum is? And this is where often there is disputes between the parties as to what a reasonable sum is. Great if the parties can resolve it. If not, then of course it's going to get referred to the courts. Now, the starting point for assessing what actually is a reasonable sum, it is a fair, objective, commercial rate. Now, let's say it does get referred to the court. I'm just going to go through a few examples of what the court looks into and what it takes into account. So firstly, it will look at the quality of the works. If there are defects in the works, then of course this is going to reduce the value. Number 2 is prior negotiations or meetings between the parties as to the price. This will be something that the court takes into consideration to determining what a reasonable sum is. The final 2 things are expert evidence and opinion evidence. Now, expert evidence is not necessary often, but it can obviously help your case if you're claiming a certain sum. And then finally, opinion evidence, say, for example, if it's a contractor claiming payment, then one of its surveyors. Of course, however, the court may not give so much weight to this for obvious reasons. So, looking at all of that, that's what the court would determine. Of course, it might not reach court. It might be that the parties settle it via mediation, through a settlement agreement, or any form of dispute resolution. But that's just something to look into if there is a dispute as to the reasonable sum. So that concludes my talk for today. So if you've got any questions in relation to quantum merit, how it applies, does it apply in your circumstance, has a contract been formed, any questions on formation of contract, then please do not hesitate to contact me and I'll be happy to help. My email is brandonsilver@silverllp.com. Thank you for listening.
Brilliant. Thanks, Brandon. We look forward to next week. Are you going to give us a giveaway on next week's, or are you going to keep it a secret?
Yeah, keep it a secret. I'll keep it a secret like last week, yeah.
Okay. We look forward to that secret being revealed. See you
Thanks,
later.
Thanks. Bye.